Good evening, ladies and gentlemen. Thank you for making it over through the cold, wet, mean streets of central London on a Monday night for this intimate setting in this lovely room for session 3 of our series of seminars discussing best practices and reforms to international construction arbitrations. Co-produced and co-hosted by the Centre for Dispute Resolution of the Law School at King's College London and Pinsent Masons. This third session is going to focus on clarity, the identification of issues and any questions that will arise within the morass of complexity of those nightmare construction disputes that tend to end up in cross-border construction arbitration. Tonight, we have assembled some veterans from a very select series of dimensions in the conduct of dispute resolution through cross-border arbitration. I will introduce them in due course. But before I do so, may I just set the scene? For those veterans in the audience, you will have heard this before. It is the portrayal of that large, clunky, complicated dispute concerning a journey that parties have taken, often multiple parties, through to what was once a common goal, completion and compliance with the wishes of the developer and the owner, but has resulted in a commercial dispute that has not been resolved by any other means known to the parties or acceptable to the parties, but this attempt at an arbitration. It may have gone on a journey of prior procedures, perhaps through a dispute board, forms of structured mediation, perhaps informal advice. At any event, a process that has itself generated a procedural complexity and a body of evidence before it comes to the doors of the arbitration. Now, of course, I'm not speaking of every other dispute, but I am setting a scene that I think is appropriate for a discussion on clarity of issues. I'm Nick Brown. I'm a partner of Pinsent Masons based in London, and I have the privilege to chair this panel this evening. And without further ado, I will introduce the panel to those of whom this group are not yet known to them. Starting on my far right with Dr. Robert Gateskill, King's Counsel. Robert is a senior barrister, a leading international arbitration arbitrator, mediator, adjudicator. He's also an author. And indeed, he is a co-author of a very important report published by the institution to whom the second member of the panel belongs, that is the International Chamber of Commerce, International Court of Arbitration, which had published in the early 2000s and again in 2019 a very significant report offering guidance on best practices in the conduct of construction arbitrations. Robert was a co-author of that report in 2019, and he brings to this evening's discussions all the wisdom of his own experience and know-how, but also that of the committee that produced the report. Nextly, in the centre of the panel is Ms. Ziva Filipik. Ziva is a lawyer and managing counsel at the ICC International Court of Arbitration based in Paris. And I'm delighted to say is a good friend of the construction arbitral community, and has given her time to this series twice now in the interests of conveying best practices from the point of view of the court. And then to my immediate right is my law partner, Edward Shaw. Edward is also a veteran construction litigator, and I'm sure is not only focused on litigation in the broad sense of arbitration and court litigation, but also in other forms of dispute resolution. He is, as I say, a veteran in the field of construction dispute resolution, so he will be speaking from the point of view as a party's legal representative, counsel, as it's known in commercial arbitration. Now, the approach we take this evening and in this series is to begin with some topics within the broad topic for the seminar itself, which I will then use to pose questions to the panel for around 50 minutes. And a member of the panel will take on the responsibility of answering the question that I've raised, and will speak to that for some time. And then the panel will itself open to further comments, maybe some dissent or some alternative thoughts. We are trying to, as I say, explore and search for practical solutions that are not hidebound by what may be perceived as common wisdom on the topic. We are trying to move things forward in these discussions. So that is the dynamics of the panel. When we get to the end of the intra-panel discussion, we will open the floor for 20-25 minutes of questions from the floor. I may warn you that during the course of the first phase of the panel session, members of the audience may be invited to offer their own perspectives. Now, on a discussion of this topic, the expert witnesses among the audience should be particularly alert to the risks of being, without any warning, asked for their views. Now, it's 9 minutes past 6, so I'm going to move to the main business of the session. And I'm going to begin with a question that I've been really bursting to ask Robert for some time now, because I know deep within there is a deep reservoir of knowledge and wisdom and illustrations. On the question, when will a direction for early incremental provisional lists of issues be worth the associated costs of early provisional lists of issues, as compared to, say, late stream or midstream lists, or indeed a list right on the eve of the hearing? And have you other experience and suggestions to make for refining lists early? Thank you, Robert.
Well, good evening, ladies and gentlemen, and it's a great pleasure to be here. King's is my alma mater, so I greatly enjoy coming back to speak. And I'd better tell you a little about where I'm coming from professionally, because that determines the line I'm taking on answering that question and indeed any other question. I'm in a niche set of chambers here in London, 5 minutes away. What we do is specialize in international infrastructure disputes covering engineering in all its forms, civil, mechanical, electrical, and so on, and oil and gas. And those of you who know how the international arbitration market breaks down will know that the first part of that, the engineering, accounts for something like 18% of all international arbitrations. And the other part, the oil and gas, is similar, about 18%. So we're talking between a third and 40% of disputes are in the sector I know about. I do not know about the other 60-odd%. So I'm afraid you're going to get my view on international infrastructure, oil and gas disputes, and it does color very much what I say. The short answer to Nick Brown's question, what's the answer to the tension between the costs of getting the issues right and starting early, and as I'm going to suggest to you, having an iterative process all the way through? How do you balance the cost with the fact that you can do this iteration, or do you have to rather wait until later on and save costs? In the sort of cases I'm talking about, the costs of identifying the issues is as nothing. It's, in electrical engineering terms, it's noise. It doesn't matter. What matters is getting the issues right. And that's what I'm going to be focusing on. How do you get the issues right? Because the issues are the backbone of a dispute. The sort of cases I'm talking about will have, and I know there's at least one person here who's totally familiar with this sort of case. The cases I'm talking about will have 50 claims, for example. Could be 40, could be 60, but 50 is normal. 50 claims, they'll concern delays, disruption, defects, and so on, variations. And each claim will have half a dozen issues. So we're talking 50 times 6, 300 issues. How do you control a dispute with 300 issues? And that's where I'm going to end up giving you my answer, which has come out of decades of experience. And it works. We'll be able to discuss it if anyone would like to later. But that's where I'll be taking you. And what I'm going to have to do in order to unpack this whole question of identifying the issues early on and at the best point, what I'm going to have to do is to give you a quick overview of the whole process of international infrastructure arbitration, because you'll see that the issues bubble up at every point. And you get this wonderful iteration between you identify the issues, that tells you what sort of evidence you need, factual, expert, what sort of legal issues arise. You identify those, you see whether you can get the evidence from your factual witnesses, from your experts, and have you got legal arguments from looking at the cases and so on. And when you've done that, you might find that some of the issues that you identified die and you can delete them, and others bubble up and you can add them. So there's an iteration. You then get a better, more refined list of issues, and then you look to see, can we get the evidence that's going to support them? And again, you go through the process of gathering the evidence, finding that some issues die again, and so on. And you do that largely as early as you can, because the earlier you do it, the more able you are to identify and get the evidence that you're going to need. And you can do that up to the point where you're coming up to the hearing. That is an absolute cutoff, because at the hearing, you're going to be calling factual evidence, you're going to be calling the expert evidence, you're going to be making submissions on the law, and they have to be tailored to fit the issues that have been identified, hopefully jointly by both parties, but in my experience, you'll often have two lists of issues, what the claimant wants you to decide and what the respondent wants you to decide. That's no problem. You just have a long list of issues. But you need that. You need to be fixed in stone before the hearing, because at the hearing, the evidence is going to come out to either support or not those issues. And the tribunal will take very seriously what the issues are. And I know for myself, the two main platforms for this sort of case are Opus 2 or Epic. There's one or two others, but those are the two that throughout the world people are using. And you can make notes on those platforms as the person is giving evidence, factual or expert, or counsel is making submissions. You as the tribunal can sit there and make little notes to yourself on the transcript, which only you can see, but which will come out. And I can tell you what arbitrators do is they identify what's being said by what issue it goes to. And so it's crucial to know what those issues are, because they're going to be used as a way of identifying what the evidence matters in respect of. So that's what you need to achieve. And how you achieve that is what I'm going to be proposing, which is a technique that I've developed over the years, which I call using dossiers. And let me tell you what a dossier looks like. I brought along, purely for my own benefit tonight, a dossier in a case that I'm working on right at the moment. And a dossier is the way you keep control of those 300 issues that I was mentioning to you. You need to identify, you need to identify as soon as you can the issues, because they determine everything that's going to be produced to support or attack them. And you can often find right at the outset of an arbitration, at the time of the notice of arbitration, that the issues are quite well developed. And that would be, for example, many of the cases I do are FIDIC cases. That's a body based in Switzerland, which does international infrastructure disputes. And to get to arbitration, you've got to go through a dispute board generally, and dispute board, of course, has adjudication built into it. So there'll have been possibly a mediation, then an adjudication, and then the arbitration, so that both parties know what the issues are at that stage. I emphasize at that stage because, as I mentioned, this is an iterative process and things do change. And I'll give you examples as we go along. And so you start out with your notice of arbitration, and there's a list of issues. You go to the defense, and what's likely to happen, because it happens in many of the cases I deal with, in the defense, it says, well, here you are, you're claiming we delayed you, we the employer delayed you on site, but you didn't give us a clause 20 notice. And in some jurisdictions, for example, England and Wales, in some versions of FIDIC, that's a condition precedent, which means that it has to be, the notice has to be given within a certain time, or the claim simply can't be pursued. In certain jurisdictions, it's not a condition precedent. So you need to know where you are, and you need to know what form of verdict you're dealing with. But there's an issue there. Is it a notice issue that is going to be fatal to the claim? And that will come up in the defense. So that immediately starts an additional issue to be addressed in some of the 50 claims that go to make up this particular arbitration. And so you've now got a developing set of issues that's growing. If it's an ICC arbitration, then there'll be a terms of reference. I'm going to say little about that because you have the expert following me, and she can tell you all about it. But you identify issues in the terms of reference. And often people are very anxious not to confine themselves too much. And so you'll get a list of issues, and then the arbitrators will add and all associated and similar issues to keep open the possibility that there can be more. And certainly it's possible that there might be more. And that can then serve as a basis for the next big feature in the whole procedure, which is the experts' meetings and reports. And later on, not in this particular question session, but after Jiva has spoken about the ICC, we're going to be looking at experts' meetings and reports. So I'm going to say little about that at this stage, but it is very important at that stage to get the experts together. And I've got all sorts of suggestions about how you make the best use of that procedure to get the experts to tell you what they think the issues are. Because the truth is that experts, particularly engineers, and I'm a chartered engineer as well as being a King's Counsel, engineers are very good at being problem solvers. And you put them together and you don't allow lawyers to confine them too much. And what you'll find is that the experts will start agreeing with each other because they want to find the truth. They want to find out what is, in fact, the underlying issue. So picking simply at random a problem. I do a lot of power plant disputes. So you might have, for example, a problem where you're not getting sufficient heat out of your boiler to drive your turbo alternators. And you think, well, the scope of works says we want so much British thermal units. We're not getting that. There's a major defect. We ought to have the whole thing redone. Put the experts together and they might say, it doesn't matter. There was so much factor of safety built into that scope of works requirement that in fact, the turbo alternators will work perfectly fine. You can have a bit of financial compensation because you didn't get precisely what you asked for. Well, of course, that changes the ball game, and a settlement is then highly likely. Experts are great. If you use them properly, you can cut down the issues, and that's got to be a good thing. Whenever I think about experts, I remember going on a site visit, and I'm a big fan of site visits. and using them as a time for getting the experts and the tribunal to have a meeting about issues. And there's a famous public school, and for those of you who aren't English, a public school means it's not a public school in English. It means it's a private school with huge fees. And there's one quite close to London. And I was involved in a dispute where they had built a new swimming pool and they had a wonderful ceiling above the swimming pool. It was all indoors, of course, and it was Olympic sized and it cost a lot of money. And the school said the ceiling had all sorts of problems with the joists and the rafters holding up the ceiling. And the judge dealing with the case in the Technology and Construction Court here in London, at that time it was Judge Newey, he was the senior judge. He said, okay, let's all go out and have a site visit. So we all clambered up and we're walking in the ceiling void, looking at the rafters and so on. And he says to the two experts, show me what the problem is. And the one expert climbs onto one of the rafters and says, they claim this rafter is not up to the ordinary standard that it should be. And I think this is the finest bit of woodwork that I've encountered in my whole career. And he stamped on the wood and the whole ceiling fell down into the pool below. Fortunately, there was no one in the pool at the time. And the judge said, I think this case may settle. So always take the opportunity to have a site visit with the experts and the arbitrators, and you never know what's going to come out of that. Now, I enjoy myself so much talking about identifying the issues. I'm sure I've gone well over time.
Thank you very much, Robert. I think you've whet the appetite for the discussion on the value of experts. I'm going to turn now to Edward. So Edward is going to obviously speak from the point of view of the legal representative, external legal representative of the party. I heard the expression background noise. Interesting, the electromechanical training of Robert's first degree came through in various parts of his comments. But turning to Edward, what do you say of the background noise?
I might challenge that. Knowing as I do today, having just put in a pitch where the clients ask me, as they are always doing nowadays, to put in a capped fee proposal for an arbitration where I've had 3 pages of information to put the capped fee proposal on. I think background noise of costs is perhaps a misnomer from the point of view of party representatives. It's fundamentally important. And I think part of that turns, certainly in construction engineering projects, on the nature in which some of these things are funded. We find, and I don't know if the audience will have a similar view, but we find that a lot of these disputes are actually still being funded by the project budget, such that if they've already got a distressed project where people are getting criticised because there's overrun and overspend, they don't want to spend a lot of money on the legal fees or the experts' fees or both of those things. And so it leads you to the decision or the process by which you reach the decision to use early incremental provisional lists. What an expression that is, such I saying that 3 times in a hurry. And comparing that to sort of the kind of more standard, perhaps late stream pre-main evidential hearing list and the factors that can influence that. And obviously the key is to balance the benefits of the early clarification of issues, but weigh it against the associated legal costs. From my point of view, that's a bit of a theme to what I'm going to say sort of constantly throughout here. And I think it is easier said than done. I mean, obviously the theory is that early incremental lists can be particularly valuable in complex arbitrations, and Robert was particularly focusing on those from a technical point of view, and also the value of the dispute where there are multiple claims and multiple technical issues. And so the lists help to clarify those key issues early in the process, and that enables the streamlining of proceedings and hopefully avoids procedural deadlocks. The problem arises is when agreeing the list itself becomes a procedural deadlock and the parties start fighting very early on as to what might be in and what might be out. The approach can ensure that only relevant evidence is presented, and that does help with the subsequent arbitration proceedings. But as I say, the preparation of the list can be extremely time consuming and costly. And of course, it's dependent on the parties knowing exactly what their case is at the beginning, which if you're up against a limitation deadline might also be more easily said than done. And I have to say that whilst I do understand the theory, I haven't seen it implemented that often to date, even on fairly significant arbitrations, and I again would welcome the views of the audience on that. It may be that possibly the parties recognise that it was, practically speaking, too hard and time-consuming to agree. But obviously there are occasions when it's valuable. As I say, complex issues, early identification does help to sort of focus the mind somewhat. And avoid surprises later. It can help manage costs by focusing resources on the most relevant matters and avoiding unnecessary work on peripheral issues, which can often become a real sideshow in these disputes. And by clarifying the issues early, the parties can avoid delays and ensure that the arbitration proceeds more smoothly, and therefore doesn't carry the attendant costs of delaying things at a point in time. Contrasted to that, late stream or pre-main evidential hearing might be more cost effective in simpler cases or where the issues are already well defined. The approach does allow for a more flexible and adaptive process because the parties can focus on the most pertinent issues closer to the hearing. But that may also lead to inefficiencies and delays if new issues arise sort of quite late on, again, potentially increasing the overall costs and duration. But there are benefits to that process, as I say, flexibility, allowing the parties to adapt to new information and developments without being constrained by that early list. Cost considerations, specifically where the case is a little bit more straightforward or there are limited issues. And of course, strategic considerations. Parties may want to keep their options open, especially if they've had to start the arbitration in a hurry because they have a limitation deadline or a deadline by reference to commencing things by reference to emergency arbitration proceedings, which is another occasion when I've seen that happen. But ultimately, the choice depends on specific circumstances. So it depends is the answer. This is the lawyer's answer, and I'm going to stand by it. But the complexity of the case, the number of parties involved, and the potential for new issues to emerge all weigh in on that. But ultimately, it's about balancing the costs, and that is an important consideration for 99% of most of my clients.
Thank you, Ed. We're going to turn in a moment to the processes of the ICC, the Article 23 terms of reference, which introduce a formality around a list of issues early in a case. I'm just going to say, though, that from my own personal experience, the articulated procedures for working up lists of issues through collaborating experts, collaborating parties, is not something that can be economically set and forgotten. It really does require, I think, some refereeing, procedural refereeing on the part of the tribunal. Tribunal needs to follow up and police the professionals in many of these cases, because the combative nature in many of these cases can work against the collaboration that will lead to a limiting of issues and their definition. And I see too often a set of bureaucratic procedural orders without the follow-up, which can lead to a lot of wastage. That's only my experience. I hope you've had more fortunate experience. Now, I'll turn to Ziva now to ask about the ICC's time-honoured terms of reference mechanism, the sorts of considerations that might go into the inclusion in the terms of reference, it being discretionary, the inclusion in the terms of reference of a list of issues.
Thank you, Nick. It's a pleasure to be here. It's also my former university. I mean, I only did the LLM here, but it's always a really big pleasure to be back, and thank you for having me again. The idea behind the terms of reference is to force a bit the tribunal to engage with the case early on. And every time we have this discussion about list of issues, is it really appropriate or is it not appropriate? And the idea is that the tribunal reads the submissions, which may be very superficial or very detailed. You can have requests that a request for arbitration. There is a full-fledged statement of claim of 150 pages, and then the answer is proportionately also long and detailed. You could also have a last-minute catching the deadline for prescription request, and then a very simple answer. In any event, for the tribunal to seize the opportunity to engage with the submissions as they are and try to establish what there is. So in principle, the tribunal should try to come up with a list of issues based on the submissions. That was the first idea. Then we already enter into the discussion of, there are two ways of doing the list of issues. Even if the tribunal decides to try to include the list of issues, it can either propose its own understanding of the issues, which I understood is what you were implying, or it can ask the parties to provide their list of issues. And sometimes the parties do not have the same idea of what the issues in dispute are. But I would say that far from being a problem, that is already a useful exercise. And sometimes we see tribunals that include two lists of issues, or three, because sometimes you have 3 sides of the dispute or more. But you could have claimant's list of issue, respondent's list of issue, and additional parties list of issue, for example, which you already made some progress into identifying at least where people don't agree of what the issues are. It's already a good step forward to having a bit more clarity what there is to decide in the dispute. And I'm going to do the same as Robert, like looking forward. Ultimately, it's not about it's fine, and the rules, the ICC rules are very clear in that respect. The tribunal should include the list of issues unless it deems that it's not appropriate. A typical example is when you have a request of a page and a half and an answer of a page and a half. Nobody at the ICC is going to chase the tribunal to include a list of issues where it's really not clear what the cases are, of course. The rules leave it open to the tribunal to assess the appropriateness of engaging with this. But I really personally firmly believe that it's a lost opportunity if the tribunal doesn't at least try to engage with the parties in cases where the request is a bit more meaty and the answer. Sometimes there is then you have a few points. One was already alluded to by Robert, which is that, and I think I'd also mentioned it, that parties sometimes do not want to get don't want to be restricted by the issues that were included in the terms of reference. However, if you look at the rules, the ICC rules, it says that after the terms of reference, the parties should not include new claims unless it is authorized to do so by the tribunal. So in a way, I'm struggling a bit to understand why such reluctance about this list of issues, because it's really the claims that define the scope of the dispute, and that you will always have to have in the terms of reference. You will always have to, I mean, the request, it's in the rules, the request should set out the claims, and the answer should also set out any counterclaims. So that is what will define the scope of the dispute, not so much the issues. The issues is the content of what will have to be examined and decided to decide on those claims. So maybe, in a way, a slightly misplaced fear of being restricted by the list of issues. What you should be very fearful of is whether you have all the claims, all the major claims. And there again, it's what does it mean that later on? So, like when we're discussing the list of issues, I think the question is inextricably linked with the claims that you have in the case, and the tribunal and the rules never. In any part of the ICC rules, you will see that the tribunal will have only jurisdiction over the claims that are raised in the request or in the answer, the counterclaims that are raised in the answer. Whereas we do see sometimes cases where there is a whole phase of arbitration where the respondent typically is arguing that the tribunal does not have jurisdiction because such one claim was not included in the request for arbitration. What the rules say is that new claims should not be brought into the arbitration unless the tribunal so authorizes. And here I thought it would be useful to share something that we see sometimes. Oftentimes we will see tribunal's decisions that have to decide because the respondent is arguing that something is a new claim, and the tribunal will have to decide whether or not to authorize it or not. And often we see tribunals that get straight into authorizing or not authorizing the claim without first even analyzing whether it is a new claim or it is not a new claim. And oftentimes, when properly analyzed, it is not even a new claim. It's just an additional argument that goes to the same claim that was included already there. So there are two layers of the analysis of whether something is a new claim or not. And again, whether or not an issue that may crystallize later under one claim or another was in the terms of reference or not, ultimately doesn't really matter. Okay, so that's my first message. Second message is that in complex disputes, I really don't see in disputes where you have 112 claims, I really don't see how you can wait until shortly before the hearing to start discussing the list of issues. It's going to be a mess. Nobody's going to be able to follow anything. Contrary to that, I'm not sure how familiar you are with the work of the commission. There is ICC Commission on Arbitration and ADR. Further to the report, the very useful report that I still refer to every time I speak about construction arbitration that Robert was involved in. There is now still a big problem of arbitration taking too long and costing too much money, and a big push towards settlement, or at least partial settlement of dispute when necessary. How is the tribunal going to narrow the issues in a dispute early enough in the dispute if we have no list of issues? So I think if we are serious about trying to settle the disputes as efficiently as possible, we need to also be serious about trying to identify the issues as early as possible. And it does not end there. Like Robert was very, very clear and I think very correct. It's an iterative process. The tribunal and the parties need to keep on coming back to it and trying to see if there is an opportunity to either outsource, in a way to say, an issue for the experts to agree and get rid of one issue, or whether it's certain issues can be bifurcated and carved out and decided earlier if they are determinative and they can narrow down the rest of the dispute. And all these things presuppose that early on in the case, you will have clarity about what the issues are, or at least where it's not clear what the issues are and where the parties strongly disagree about what the issues are. Of course, again, with the caveat that when you have a short request and a short answer, I mean, you can only do as much as you can do. In that sense, again, the rules are flexible. The rules say the tribunal should draw up the terms of reference within 30 days of receiving the file. The court has the power to extend the terms of reference. The court is enchanté, always very happy to extend the terms of reference where there is work, there is discussion going between the parties and the tribunal to perhaps, in this case where you have a page long request, the tribunal may ask the parties to amplify their case, to clarify their case, and then we will extend the deadline for the terms of reference, and that's fine. I think that as soon as possible, the tribunal should engage with the parties to do that. And the other thing is that sometimes I hear, oh, we don't want to make the terms of reference too detailed and the list of issues, because then when the list of issues changes, we need to issue amended terms of reference. This phenomenon, this urban myth of amended terms of reference, which doesn't exist, it's not necessary. I mean, when the list of issue changes with during the case, the tribunal can just issue a new list of issues as agreed or as determined. And that is, did I forget something that I wanted to mention? I think that's pretty much what I wanted to mention.
The CMC follows
Yeah.
sign
Yeah.
signature.
So the CMC, does it follow or does it precede the terms of reference? So it depends, right? It's a good question, actually. When it's all clear and the tribunal can decide the terms of the issues, procedural and substantive list of issues, quite clearly it can issue the terms of reference, and then they can have the terms of the case management conference. But sometimes I wonder, when the tribunal goes, oh, it's not appropriate yet, what if the tribunal got together with the parties and just discussed this? Sometimes we see, and when I think it's a very uncomfortable situation when you have no clarity about what the case is about. And sometimes we see tribunals telling the parties, okay, at the case management conference, we're going to discuss the procedure and the timetable, but we would also like you to make a 30-minute presentation of your case. And then we can have a discussion around that. And that sometimes will allow the tribunal to then be able to draw up a list of issues. And it's already an opportunity that was used well. And the final point, because it's been going on for a bit long, is where you have, doesn't happen so rarely, where the respondent is saying, I'm not going to even discuss the merits of this case because you have no jurisdiction, this case should end up now. So even there, tribunals often get, and parties get really focused only on the jurisdictional issue of whether one party has signed or is bound by or is the right party and so on. And sometimes then, only when drafting the award on jurisdiction, the tribunal actually realizes that it doesn't have enough clarity about the substance of the claims to be able to really decide the issue properly. So even in those cases, potentially, and even to determine the procedure appropriately and to issue the procedural timetable, arguably, you need to have some idea about what the case is going to be about. So it's a good idea sometimes to, when the case is, the submissions, the request and the answer are very thin, to ask the parties to elaborate, and especially if the parties are asked to bring in-house counsel or another party representative, that can be a very effective tool to clarify, to get a lot more clarity about what the case is going to be about.
Shiva, thank you very much. I'm going to turn to Ed to invite him to offer perspectives on how one may get to that clarification phase.
Occasionally with great difficulty. The best example I can think of is I had an arbitration last year. Thank you. Sorry. Arbitration last year, which was we were the supplier of solar modules. I won't be giving too much away with that. The EPC contractors sued our client and commenced arbitration proceedings. And we didn't know what the hell had gone on site when these things were installed. We basically sent them and they were delivered, and that was it. And so producing the substantive defense was quite challenging because we didn't have the technical detail to be able to sort of set out with any great precision, certainly not in the answer in the first instance, our positive case of what we say happened, and therefore why the defects, as it was, had manifested. And I think that's where the difficulty can arise, because when you're coming up with a list of issues, sometimes it can be very, very early in the process. And I think the only point I would take, well, the main point, and I think actually it resonates, it's a similar point to the points that Gilles has been making, which is a proactive tribunal is absolutely essential in all of these things. Not everyone is as proactive as Robert is, with the explanation he gave at the outset about this sort of iterative process of forming the dossiers. All too often, I think, sadly, we get arbitrators who they want the CMC at this point in time, and then they don't want to hear from the parties again until they've got the sort of pre-hearing review at this point in time, and there can be 24 months in between. And that can cause real issues because, as you say, I think often it needs a policeman to keep an eye on these things to try and keep the parties and their experts to the straight and narrow, in order to ensure that these points are, that the cases are understood, that there's a degree of flexibility so that parties can develop them without necessarily moving away from the sort of the kind of basic issues as presented. And I suppose the one point I was going to make there is a soft point really. And I thought the techniques that you were talking about, Gilles, were really interesting in terms of, grilling in-house counsel of the party representatives. I think we've got at least one member of the in-house counsel here, but I'm not going to point to them. But I think because that might be quite challenging, but quite helpful, because often we have a real battle in that way. I think for me, there's a soft point around that process where you are choosing your arbitrators. And obviously it's down to the parties to be very familiar with the candidates that are out there and their particular skill sets and their particular approaches, because I think when you have that point shortly after you've nominated yours, where you can have a discussion, and you don't have much opportunity to do it, but you can have that brief discussion with your arbitrator where you sort of try and get across the case as you see it, and perhaps at that point in time the challenges as you see them, for instance, documents and access to information and things like that. That's the key point, a sort of a soft point in the process, which I think is fundamental to trying to convey to sort of the party nominated arbitrator to then get through to the other side's nomination, and indeed the choice of chair and the chair themselves as to what those issues are, so that they engage with the process and really sort of take a grip of it quite early on, because often it's not always possible.
And it's interesting you say police, and one thing is, yes, of course, parties should be monitored and kept to, and also the rules, the ICC rules, do not only impose on the tribunal a duty to ensure that the procedure is as efficient as possible. Also, the parties have the same duty, and the parties oftentimes have to be reminded of that. But that's one aspect. But the other aspect is, I see it more as a teamwork. Is like you're also helping the parties to see that, yes, this may be an issue, and it's a real issue, but it's irrelevant to what I will need to decide the case. And sometimes you also help the parties to see that they don't have to pursue an issue, because as it's not that it didn't happen that way or that they are wrong. It's just not necessary. It's not really necessary to decide that issue, because and in a way, it's working together. The parties help the tribunal to understand better, and the tribunal helps the party to understand also better what will be required of them. So in a way, it's like it's a two-way process.
Absolutely. Now, I've been watching the arbitrator's pen, and I think that Dr. Robert has some observations, maybe even a story.
Right. listening to the previous speakers, of course, is fascinating. Jiva is the expert on ICC procedures, and she knows her way around this wonderful book that the Secretariat of the ICC produces. This is my copy, and it says so there, so no one can steal it. I emphasize that because Jiva used to own a copy and someone stole it. So she now has to rely on a version on her laptop. But you will find a wealth of very useful information in that ICC book. And you do need to know your way around the ICC rules when you're grappling with these sorts of questions. And Jiva made a really important point when she drew the distinction between an issue and a claim. And you'll recall when I started, I said you could get 50 claims in a huge case, and then each claim will have half a dozen issues, and hence you get 50 times 6 equals 300. And that distinction must be borne in mind by everybody all the way through, because as Jiva pointed out, it's claims that can't be added later. Issues can come or go. I say go. People often think, why should an issue go? If it's an issue, it stays there. I can give you an example. I was appointed as a sole arbitrator in a case worth about 30 million and US dollars. And the one party, neither of them from the UK, the one party sent in its terms of its notice to arbitrate, and it explained why it had delay, disruption, defects worth 30 million. And then it added on another claim. It said, damage to our reputation, 50 million. So a 30 million claim was going to turn into a 30 plus 50 equals 80 million claim. So when we got together for our first procedural meeting to discuss the terms of reference and what issues were going in, I said, I always find the ICC procedures very interesting because unlike, say, the LCIA and SIAC, with ICC, it's basically ad valorem so far as the expenses of the ICC and the arbitrators are concerned. What that means in practical terms is that you look at how much money is being claimed, and that determines the ballpark in which the arbitrator's fees are going to be set and the expenses of the ICC. So I said, you know, the claimant has clearly suffered a grievous attack on its reputation because it wants 50 million. But of course, that will put the costs marginally higher. And they said, could we drop that one? So claims do go. And of course, as I mentioned earlier, claims go when parties realize there's no evidence to support them. And I'll talk more about that when we are discussing experts. But just let me see if there's anything else I need to pick up from what we would. Yes. Final point. Because what people want to know about when they contact you, this is a point that arose in the context of what about when you're interviewing arbitrators before the case actually kicks off. There are protocols, for example, from the Chartered Institute of Arbitrators and others, on what parties may ask potential arbitrators before they've appointed them. And what they should not ask is what are their views about well-known issues. For example, I mentioned the FIDIC Clause 20 notice provisions. And some arbitrators take a view that there's a condition precedent. Others say, no, there isn't. What you are not allowed to do when you are deciding whether or not to appoint Miss A as your arbitrator is to say to her, what's your view on that issue? Because it'll be an issue for sure in the case. And what they're trying to find out, understandably but illegitimately, is how she is going to decide that when she's in discussions with her co-arbitrators. And if you're an arbitrator, do remember that. Do not discuss issues of that kind when people are contacting you prior to appointing you. I think I've picked up the points I wanted to pick up, and so I suspect that probably brings an end to that particular round.
Thank you very much, Robert. All right, now let's turn to the third and final set piece aspect of the discussion, and that is expert issues. Ears are pricking up, I can see, as I mentioned that. Now, we are a bit short of time, so I'm going to propose that we address this button as an open forum, in the sense that if you'd like to ask a question, if my panelists wouldn't mind, you raise your hand and we'll take it in our stride. That way we'll reach the end of the proceedings without disappointment, I hope, on the topic of probably greatest interest to the majority of the audience. So turning then back to you, Robert, please, for your recommendations, proposals with regard to the treatment of expert issues and their clarification.
Right. What I am going to say, I'll keep very short, because I know we want to open it up to the floor where there are some eminent experts here, some of whom have appeared in front of me a number of times, and I've worked with them in many cases. So I'd certainly like to know their views. What I'll simply confine myself to saying is getting the experts' input is crucial. I mentioned earlier, experts are problem solvers. They will find underlying issues which need to be addressed and which are not apparent from whatever the parties have come up with. So the way I would go about doing that is a series of meetings. Now, I know what I'm proposing runs up the costs, and I know that certainly some of our panel here don't like running up the costs, but my experience is money spent on good meetings, productive meetings, good reports is money well spent, because it focuses everybody on what matters in the issues, and it gets the answers often, so that some issues can simply be disposed of. And I'd like to hear what the experts say about that. But crucial to that is at least one meeting where you have the tribunal, you have the experts, all the lawyers for the parties are allowed to attend, but they're not allowed to say anything unless they get leave to speak. And that is because, in my experience, if you allow the lawyers to the so-called experts meeting, you never hear from the experts because the lawyers dominate they don't want their expert to make any concessions, whatever, and they will squash him or her. And we want to avoid that. And I'll happily elaborate on this if you ask a question about it, but I think I've gone on long enough.
One question about timing of that meeting, midstream, early stream, late stream.
Yeah, it depends how well prepared the claimant is in its notice to arbitrate. If it's FIDIC, then it's come through at least an adjudication as part of the dispute board, and there are some real issues, and you can, assuming it's ICC, which generally that is the case, you have your first procedural meeting, and at it, you, the tribunal, say, we really want to get the experts involved here. Let's have a meeting on such and such a date. They don't produce reports prior to that meeting. You all get together, and the tribunal, using the list of issues that's been generated in the course of the preceding DAB, talks the experts through those issues one by one and gets their views about what really matters. And that's crucial. And once you've done that, you're in a position where the experts can then go away and produce their reports, because they know what the other side are thinking, the other side's expert is thinking, and they know what the tribunal is interested in, and it's a very productive way of getting good first reports. When you've got those reports, then you can get a joint report, which will cut down the issues in my experience, and if necessary, the experts can meet on Zoom thereafter, very low cost. But the more the experts meet, the more productive outcome you get.
Thank you, Robert. Okay, so I'll just pause. I've got a question of Ed, but before raising it, I wonder if anyone would like to venture some observations regarding Dr. Roberts' proposal. Yes, sir. Please introduce yourself.
Good, sure, be sat at the front.
Hello? Yes. Ewan McLean, Elixir Experts. Yes, I mean, fascinating 300 issues, and that those can expand even more by the time the experts decide to do things in different ways. And my observation actually is in more recent times, I've seen a trend for joint expert reports before the actual expert report. So that's crucial on the timing, just before. And at first glance, it's a bit alien, or it jars a bit because you want to get to your opinion, but you've got to have a joint report first. But I just wanted to point out some of the benefits of that I've found. So if you're dealing with, say, a delay dispute in construction, you might agree the baseline program. You might agree the as-built data you're going to use. You might agree the methodology that you're going to use. And although it makes life a bit more uncomfortable for the experts, I think that's the benefits have been great. So I don't know if you've seen that more frequently recently, or you would agree with it, that you have a joint expert report before your actual expert report.
I actually have that in a case at present with bells on. Procedural timetable requiring a first joint statement, identifying what's agreed and what's not agreed. A second joint statement, identifying what's required in relation to the issues that each expert and jointly as well are identified. An interim progress report indicating the progression of the experts' consultations with a view to agreeing what's required, And then, of course, the reports in chief, followed by reply reports, and then a third joint statement. I haven't quite worked out in my own mind what the content of that joint statement ought to be, leaving aside what it will be in the end. But I think it's a wrap up. And so that's over the course of around 9 months, with case management conferences taking place ad hoc to keep everyone on the straight and narrow. So I have seen that, and I've seen that increasingly, and I've seen published articles that some others no doubt will have seen that are proposing that intensive approach to corralling expert issues. Edward, views?
I agree with all of that. No, I mean, obviously the alignment of expert evidence is absolutely key, and there's nothing worse when one party's expert disappears off and says a load of things around a set of assumptions, and your own expert says a set of different things around a different set of assumptions, both of them with access to different documents. So I think for me, agreeing with that, the key is to align that evidence. And the technique I've seen is a little bit of a halfway house, where the experts, certainly in case of delay, have been asked to go away and agree methodologies and agree data sets and agree the material that they need to see, whether it be in the hands of party A or party B. And that then helps, it sort of brings into an earlier stage, depending on the process that you're following, a certain element of document production. And it helps the tribunal, I think, in terms of sort of understanding the relevance of documents, materiality, and all of that sort of stuff. So it can have tremendous benefits in that way. From a technical expert point of view, the approach was to get the experts to agree the sort of testing that needed to be done, site visits and the like, when, how, including laboratories that were seemed to be acceptable by both parties and things like that, in order to get to a sort of a common ground as to level of defects and deterioration rates and things like that, before then getting into the causes of that and why that might have happened. So I do think that sort of anything that engages the minds of the sort of experts, the lawyers and the tribunal earlier as a team, although clients often don't like to hear it that way, because you're in opposition and we're all fighting a battle to do the best job for our client, but nevertheless to help sort of streamline that process and get a common ground somewhere, I think the better, and I've seen it be very effective. The problem I had with the example with the technical experts was that the other side's experts swore, like it was day, and that our guys didn't need to see certain things, and our guys were saying they absolutely needed to see those things in order to be able to form any kind of review as to what the hell had gone on.
Thank you, Ed. Any other comments before we open up for questions from the audience? No? All right.
I have a question for the audience.
Excellent.
For the expert in the audience, we have this eternal debate about whether, memorials or like common law style pleadings are more appropriate. And I think it's most interesting to hear from the experts which one is more helpful and more efficient. So if anybody has views to share on that, I'd be interested. Memorials being when everything is, the submission already is supported with the evidence, including the expert and witness statements and so on.
So if you contextualize that in terms of having a mature case from which one can then discern what are the issues in the case with some certainty and stability proceeding through the course of the case, as opposed to having very short form, perhaps common law pleading just the facts in a sequential order, early upfront statement of the case may seem to be the best way to identify the issues earlier. But Jiva's question goes to then, should that include, is an expert comfortable with the inclusion of her or his report in that initial memorial?
Before seeing the other party's case, right?
Mm.
Fully.
And that also requires early engagement with the experts.
You cannot talk if you don't have a microphone.
Thank you.
It's a general statement on life.
I was going to say that involves early engagement of the expert as well, and going back to costs and people trying to keep costs down. You know, we as the experts are always, you know, we're in the same boat as Ed was saying, that people are trying to say, right, you know, we want low costs, we want fixed costs, we want all of these things that are stopping us do what we think our job is, which is to try and get to the bottom of the issues. I'm all for it. I'm all for, you know, trying to work it out as early as possible, so that we all understand what the case is. But sometimes clients don't see it that way. They're the ones that may need the kind of education of the benefit of following that process.
Has it ever happened that you prepared a report and then you had to actually, because once the client that engaged you saw the other side's replies and defenses, or the other side's case, the picture changed and the report became largely or partially
I've seen it from the other side, where we've been on the other side, and the initial expert report initially served becomes somewhat irrelevant.
Yeah,
and then
which
that
is not amazing. Right?
Yeah, exactly. Which, you know, and I think everyone's just nervous about putting their case forward and you know, nailing their colours to the flag. You know, people like to see things evolve, and it's yeah. Like I say, I had one recently where the other side's experts' first report was pretty much totally irrelevant, and we all moved towards the other side things. But just going back to the other point made, it's much more common now to do the joint, you know, joint expert. That's becoming, we're seeing that more and more, that you have a joint meeting. If you can agree the data, the programs, the methodology, then all of a sudden you're on the same page, you know, from a very early stage, rather than different methodology, different data, and you're just the two ships that passed in the night. Yeah.
Thank you. Professor Nazzini.
Yeah, I mean, I'm not an expert, or not an expert witness, perhaps expert on minor issues, minor things. But one thing I wanted to say was that, so to Jiva's question about pleading style and memorial style for experts, there is, I mean, I have my own view, although I'm not an expert, that, you know, obviously, as we have seen, I mean, if you start with an expert report, but you don't have the full evidentiary picture, then, you know, you may not, but by definition, I think, and it has to be accepted, that report may be incomplete and may have to change. One thing that one can do, I think, is, you know, without going into this stark choice between a pleading style or memorial style, is, for example, to go memorial style, which means full memorials with witness statements, legal authorities, blah blah, documents, blah blah blah, but without the expert reports, actually. So you plead everything memorial style, but the expert report comes after that. You know, it seems to me, in the appropriate case, it's the best of both worlds, really, because you have the procedural efficiency of memorials, which means that you don't have to have this long sequence, etc., but also the procedural efficiency of having experts coming in when actually all the evidence and hopefully all the issues are there, and they can really do their job without then big surprises. There can always be surprises, obviously, but at least you have as full a picture as you can have. And when expert evidence is key, I think it's possibly a good model.
Yes, I think that recognizes, no offense intended, but the experts really sit at the bottom of the analytical food chain, in the sense that they are going to come to a conclusion on basis of all that has preceded. And then the quantum experts are very much the opposite of the apex in terms of that analysis. So it seems to be an economical hybrid to the memorial. Thank you very much. I would like to invite any questions before we soon close the proceeding. It's been a very intimate discussion and group this evening in this very nice room. I thank you for your patience. As I said earlier, coming out on this cold, wet evening. It's been a delight to have this conversation, for me to chair this evening. I have some thanks to say, and then I'm going to say good evening. I would like to thank, first of all, on behalf of the panel, the Centre of Construction, Law and Dispute Resolution, of course, my own firm. I'd like to thank the producers of the series and the session, Vicky Clark and Raquel Macedo Moreira. They are ever so supportive of the series and the panels and the panelists. I'd like to thank our brilliant panelists for this evening for sharing their wisdom, thoughts and funny stories this evening. And I'd like to thank you once more for your patience in taking in this panel this evening. So I may propose a round of applause for everyone.